Hello, ladies and gentlemen. Welcome back to the INTP stream. Uh, I've been thinking about the subject of government engineering and policy engineering, and trying to bring a systematic engineering approach to government and optimizing its design to see if there are points of weakness in that system that we could perhaps remedy and make the overall system better at serving its purposes. I talked about the executive branch in a previous video. I talked about the legislative branch, and in this video, I'm directing my focus on the judicial branch. So, with the judicial branch of government, the reason that we have a Supreme Court and an appellate system and a trial court system is because we have those institutions to ensure that legislation is legally valid, that it comports with other legal and ethical principles that we have, that it comports with the overall system of government, that it doesn't violate precedent, that it's essentially the Supreme Court and the appellate system and the court system, and especially the appellate and the Supreme Court, not so much the trial courts, where the validity of law is not questioned, it's rather just applied. And however, you have your courts of I'm not sure if there's a distinction here, but you do have your courts of enforcement and you have your courts of review. And your courts of review are going to be your appeals courts, and your courts of enforcement are going to be your trial courts. And I'm not sure how each individual state court system is laid out. I think they each follow the same general structure as the national court system. But the question is, in this video, I'm covering the topic of the politics of judicial appointments and whether we should have a political nomination process for Supreme Court justices, and what potential alternatives would be to that. I think there may be one specific alternative for the Supreme Court. A common objection that I know is brought up is, the question of whether the Supreme Court nominations and the Supreme Court nominee approval process, should that be a political matter? Should it be handled by democratically elected representatives and democratically elected leaders? And I don't really see a way around. I don't see an alternative to political nominations for the appellate courts, right? Because it's the charge of the duty of the president, the national president, to nominate the appeals court justices of the district courts. And ultimately, it's up to the president to put forward a nominee for the Supreme Court. The question is, should nominating Supreme Court justices, and generally the question is, should the nomination and vetting of those nominees and approval of those nominees, should that be a political process, or should we try to remove politics from that equation? And I think that ultimately there may be a better alternative to the current system by which we presidentially nominate, Supreme Court justices, and we senatorially approve or deny those nominees. I think there may be a better alternative, at least for the Supreme Court. I can't think of a better alternative for the appeals courts, the lower courts, the courts directly auxiliary to the Supreme Court. I don't really see an alternative for those. I think probably, the president should still nominate those district appeals court judges, the federal appeals courts. I think the president should probably do that. And I think that it's fair that we have the normal, Judiciary Committee approval process in Congress to ensure that we've got, living people, sitting on those courts, on the appeals courts, the federal appeals courts. The question is, should we follow this, presidential nomination procedure for the Supreme Court? and the typical procedure of vetting the nominees before the Judiciary Committee and the Senate, and then having those nominees approved by the Senate. Why it's necessarily the Senate and not the House that does this, I'm not sure what the teleology is there. In any case, yeah, what's an alternative potentially to a system by which we presidentially nominate persons to serve on the Supreme Court when one of them dies, and when one of them expires? And what's a potential alternative if there is one that comes to mind? I think for me there was one that came to mind. I don't necessarily think it's a good thing for politics to be involved in the nomination of Supreme Court justices. I think that what it leads to is, I think that you have with Republicans and Democrats, Republicans tend to prefer your textualists. Democrats tend to prefer non-textualists. I won't call them activists. Judges. I don't really like that term. But the Democrats and Republicans prefer distinctly different judicial philosophies. And so what this political process of nominating Supreme Court justices becomes is just, packing the court with your respective, philosophically compatible justices. I don't necessarily think that that's a good thing. I don't think that I don't think it's a good thing. I don't think it's necessarily a good thing. I don't think that, and this kind of, I guess, goes back to, it doesn't really go back to the party system. It just goes back to the conservative and the liberal mindset. And for whatever reason, conservatives tend to prefer these strict, rigid textualist judges, which I think is the proper role of the judge anyway. I'd be more conservative on which, on the kinds of justices and judges to be preferred. These are, well, this is the hard thing, right? Is the Supreme Court is checking validity, right? That's the purpose of the Supreme Court. It's trying to figure out, okay, is this legislation, is this executive order, is A or X or Y or whatever, is this valid? Is this legally valid? And if it's not, we'll strike it down. If it is, we'll approve it. Does this law conflict with other constitutional principles? And in the task of judging the validity of law, there's a lot of ambiguity, right? I mean, there's differing interpretations about what text means. And so being a judge at that level isn't a simple matter of applying text. It's about interpreting text. And the very act of interpretation involves, well, the very act of interpretation is naturally going to involve ambiguity. This is the thing, the conservative mind, the judges apply the law, we just want them to apply the law. That doesn't even, at that level, you're not applying law, you're interpreting law. So the idea that on the Supreme Court we should even, we ultimately don't need either textualists or whatever the alternative of that would be, which is purposivists, I think is what Antonin Scalia calls them. It's hard to say, you can't, the problem with your really what it means, okay, to be a textualist is essentially, I think what it means to be a textualist is to be a literalist, okay? Whatever that means. Textualists tend to have a more literal, canonistic way, a fundamentalist way of interpreting text. And, they claim that they can know the definitions of words by looking at dictionaries, and that they can do these types of, they can look, to what the law meant, they're essentially all about, okay, this is the difference. I've just discovered this. Okay. The difference is this: your conservative judges, they're applying the law. They're applying the intentions of those that conceived of and wrote the law in a literal fashion. Your more liberal judges are not really trying to enforce or apply the original intentions per se behind those that were creating and conceiving the law. They're more about they recognize there's genuine ambiguity, and they're more compromising. We have to figure out what works in the context of the broader picture. There's a lot of ambiguity. We really can't know. I mean, the thing is that these textualist conservative judges, they think they can know what the intentions were behind that particular law, and they can't. I mean, they can to an extent. They can look at congressional records, and they can look at past speeches, and they can look at any number of other kinds of evidence. But I really don't know if I'd say that they can really know what the original intentions were of those that put the law into place or conceived and designed the law. I don't really know if they can say that. Your liberal judges recognize that you probably can't say that. Conservatives don't like that because they want the judges to be limited by something, right? The thing is, conservatives want the judges to be limited, right? They want them to stick to canon, the old way, the kind of old guard fashioned way of interpreting text, and especially to enforce the original intentions of the law, right? Liberal judges, so they don't like liberal judges because the liberal judges are less bounded. They're not unbounded. They still bind themselves to the text, of course. That would be absurd if they didn't. All judges are textualists. But conservatives don't like this more liberal mindset of, well, it's actually ambiguous. We have to figure something more intelligent out, more compromising. Conservative judges desperately want to stick to what they think, to the intentions they think they can derive from text and canon, and they call that canon, and they enforce that. Conservatives like it because that makes the judges more rigidly bound to something. Whereas liberal judges, in their genuinely ambiguous way of looking at the law, as it being an area of ambiguity in the domain of the Supreme Court, you're interpreting rather than applying. So they just recognize that's an inherently ambiguous process. We can't really know what the original intentions were. If we can know, then we'll apply those, but oftentimes we can't. So conservatives don't like that because then those judges are less constrained. While they prefer judges that do constrain themselves, even if they're not constrained really by anything definite. Now, so in any case, I won't render a judgment. I think in my discussion here, I think that the more conservative mode of interpreting text, by looking to what trying to discern the intentions behind the text, I think it's personally, I think it's an unrealistic way of trying to apply and interpret law. And though I do think that conservatives like that because those judges are more constrained, and they dislike the so-called liberal judges because they're more unconstrained. And so, but this whole idea that of judicial philosophy and everything else, that these judges have distinct, liberal judges, those nominated by Democrats have a particular judicial philosophy, and those nominated by Republicans have a particular judicial philosophy. And I don't think that. So when when Republicans are in power, you get these type of judges that claim to interpret the original intentions of the law and then just simply apply those intentions. I mean, they argue, right, that the assumption they don't question is whether the assumption they're making is that they can know what the original intentions were and then applying those intentions, right? Liberal judges are a little bit more they're a little bit more uncertain about how original intentions come into play. I mean, obviously they should be considered, but if they can't necessarily, so this is just the difficult part of what the Supreme Court justices do, this type of judicial review, which is interpretive rather than it's more of an act of interpretation than enforcement. It's very difficult, So So the judges just have fundamentally different personality types and different ways of looking at law in the world. And I don't think there really is such a thing as an activist judge who's just going, conservatives have this caricature of your Democrat chosen judge, who's just a flagrant disregarder of precedent and destabilizes everything that they want to preserve. Even though in many ways they would prefer an activist judge if that activist judge were pursuing conservative ends. So there's an element of hypocrisy here. I don't think many people really go too deep into how complex judicial interpretation, rather than it's not an act of enforcement, it's interpretation. It's ambiguous. And the inherent nature of that role is interpretive rather than applied. They're not the executive branch. They don't enforce. They apply, they don't enforce. They're not the legislative branch. They don't legislate, right? At least no judge really conceives itself as him or herself as a legislator. And that's just a caricature that the conservative media likes to put forth because it plays into their narrative that liberal judges are just unconstrained hippie bastardizers of what we want to preserve and cherish. So I don't get it. But I need to say this, with this nomination, this highly politicized nomination process, right? I don't think that it generates very good. I don't think that it generates very good justices necessarily, and I think that I think that it's just. I mean, okay, all right, okay. So now I'm just stating opinions. What's a potential alternative? Okay, I think one potential alternative could be, instead of having a political nomination process, right, for the Supreme Court, I don't know if politics should be involved at the level of a Supreme Court nomination and the approval of that nominee. I don't know if democratically elected representatives, political persons, as they currently are really qualified to ensure that we so it just ends up being the case that when Republicans manage to get one on the court, it's this justice who claims to be an originalist, but is going to be an activist when he's pursuing conservative ends, and is going to claim to be an originalist. He's going to try to enforce the original intentions, but he's going to assume that he knows those intentions because he thinks he's God or something. Even though he doesn't know those original intentions, he probably doesn't. Text usually conveys the intentions. It's not that difficult. This is why the Supreme Court doesn't divide too harshly. Because most of the time the text can tell you the intentions, and it will try to make it comport with existing law and apply precedent and yada, yada, yada. But it's in these areas where the court becomes divided philosophically and methodologically, specifically on how so on how it renders a particular interpretation. And so there's just ambiguity within this interpretive landscape. Okay, so what would be the alternative, and what would be the problem with politics really being involved like that? I think what it leads to, Republicans manage to get one in, it's just going to be a more or less Republican judge. They're going to claim to be originalist, but they're going to be activist if they've got a particular interpretation that swings in the conservative direction. But they're going to claim to be originalist when, they don't have when they think they know the intentions of the law, they're just going to enforce those intentions, And when it's ambiguous whether they can, so if the conservative judges think they can know the intentions, and they think they feel certain about that, well, they just apply the intentions. They're not complete charlatans. If their assumption is that I'm going to enforce the original intentions, right? So if they think they can know the intentions and their attitude is to enforce the intentions, they're just going to enforce the intentions, whether or not it renders a conservative or Democrat or Republican result. they're still honest and wise people fundamentally, and they're not going to throw out their whole methodology in order to act about conservative uh, a conservative ruling on a thing. And your liberal judges, and then when Democrats are in power, you get these other types of judges that, for one, they don't really, they're most, but see, it doesn't really, I mean, they don't end up, the liberal judges really aren't really that different. This is why the court's not just a bunch of politicians with different parties. If that were the case, then it would constantly divide. Oftentimes the court's unanimous. So these judges really aren't fundamentally different. I mean, if they think they can know the intentions behind the text and they see how it comports with existing law and precedent and everything, they're going to output something that, even if it's a conservative result, they're going to go for it if they think the law. So really, all judges conceive themselves as the appliers of law, although at the Supreme Court, where there is ambiguity, there is the landscape of interpretation that makes all of this very difficult. Okay, so is it necessarily a bad thing that politics is involved in the process of your Supreme Court, nominations and approvals? I don't know. I really don't think it necessarily leads to more qualified justices. I don't think that. I think that you've got to have people at this level. I think fundamentally, I think that experience is important. I think experience is important, whether you're a conservative or a liberal. And I think that these judges just need to have a ton of experience in the courts, applying the text, interpreting the text, learning about law. You shouldn't have any kind of novice going on to the Supreme Court. So what I would suggest, an alternative to your typical political nomination and presidential nomination and Senate approval process, I would replace that with automatic appellate promotion. Okay, so what do I mean by that? Well, instead of presidentially nominating someone and then senatorially approving them, then they go on the Supreme Court. I would say that the next Supreme Court justice, after one expires, should simply be the longest serving member of one of the federal district appellate courts. And then it's not a politicized, political presidential nomination, Senate approval, Supreme Court justice instatement process. We bypass all of the inefficiency of that, all of the scandal of that, all of the just misled and confused bullshit of that. And the next Supreme Court justice, after one expires, is the longest serving member judge on one of the whoever that is on any one of the federal district courts. And then it's just a process, rather than a political nomination, it's a process of automatic promotion to the Supreme Court, right? So if you just happen to be the longest serving federal district court appellate judge at that time, one person expires on the court, well, you're automatically instated in that seat. And then there's the element of randomness in that, which I quite like. I think that then it's not determined. The philosophy of the next Supreme Court justice is not determined by Democrats and Republicans. It's simply determined by the luck of the draw. They might be more liberal in their philosophy, or they might be more conservative, but it doesn't give these parties the ability to bastardize the process and situate someone philosophically compatible with them in an intentional sort of way to then sway the Supreme Court in the direction the party wants, to keep the Supreme Court in line with the party's judgments on things. I don't think that who becomes the next Supreme Court should be decided by parties. The next Supreme Court justice, I don't think that should be decided by parties. I think it should be decided by the people in an indirect fashion. And ultimately, your federal district court judges, the president still nominates at this level. I think politics is fine at the level of the appellate courts, the federal district courts. I don't think politics should be involved at the level of the Supreme Court. I think that at that level, it's already such an interpretive and ambiguous process of interpreting the law and figuring out what it means and what we're going to render a judgment on, that it doesn't really, so really what I'm saying is there's a reason that the founders, I think that really the problem is not so much the, with or without parties, you're going to have your liberals and your conservatives. There's a reason that humans split into this binary where you've got your progressives and your conservatives, and you've got that basic dichotomy, right? I just don't think that the parties should be deciding who becomes the next Supreme Court justice, right? I don't know, because it's very rare. The parties with the Republican Party, usually, I'm not sure how these map over onto each other. They're going to choose someone who's philosophically, judicially conservative, but also that person's probably going to identify as a Republican privately. I think that's true for Antonin Scalia, Clarence Thomas, who are the other conservatives? Brett Kavanaugh, Tim Gorsuch, I think his name is. Are any one of these people identifying as a Democrat? No. No, the Republicans are simply putting a Republican onto the court, okay? And it's the same with the Democrats, right? It's the same with the Democrats, right? I mean, Sonia Sotomayor, Ruth Bader Ginsburg, Stephen Breyer, any one of the other liberal justices, I can't think of the other ones, or Elena Kagan, right? All of them instated by Democrats and naturally approved by Democrats. Of course, there is some compromise made between Republicans and Democrats at the level of the Senate Judicial Committee when they vote on a particular candidate. Any one of those people, nominated by Democrats, identify as a Republican? No. So it's, to me, what this creates is when you have, because we have to concede there's going to be this shitty binary party system, Republicans and Democrats, we're going to have to concede that thing exists, whether or not we want it to. And, we're going to have to concede that it exists, whether or not we want it to. If we have to assume that there are going to be parties, right, the Republicans and the Democrats, then I would say that the Supreme Court nomination and instatement process, when justices expire, it should not be political, meaning it should not be controlled by the parties in power. I think that it's far better. I don't think that ensures they're more qualified. I think it means that you have Republicans. I mean, there's the quote, judges are politicians in robes, and you're just going to get Democrat nominated and approved. You get a Democrat on the court, Republican. It's a little bit more complex than that, but not that much more, right? So as long as we have to concede that there are these parties that sort of bastardize the whole process of democracy and ultimately negate it anyway, then I'm going to have to say that for the Supreme Court nomination and approval process, that should not be political, meaning not controlled by the parties, and that we should move away from a political nomination process toward an automatic appellate promotion process, where when a Supreme Court justice expires, the next Supreme Court justice is through a process of automatic appellate promotion. The next Supreme Court justice is the the longest serving appellate justice on one of the federal appeals courts. So I'm just arguing that we move away from a a political nomination process for the Supreme Court, that we protect the Supreme Court from the political squabbling of the parties and protect it from the parties ultimately, and that we move toward a system away from this party bias toward toward a system of as I call it, automatic appellate promotion to the Supreme Court. When one of the justices expires, the next justice is automatically going to be whoever the longest serving justice is on one of the federal appeals courts. I think that's a much better system. It protects the founders' sort of vision for what the Supreme Court should be, which is an objective body, right? The Supreme Court, we have to ensure that at least at that level, right, we'd have to say that we don't want politics involved whatsoever at the level of the Supreme Court. That ultimately then leads to rulings that support, one or another party's motives. It needs to be purely random, purely objective. And I think ultimately that system produces more objective, less political rulings. And that's, better. This video is more of a deliberation. I want to refine my thinking on this a little bit more. So I'll title this video A Deliberation again. And then in part 2, I will propose a policy solution in a way that better summarizes the points that I've made and crystallizes my thought on the matter. So again, I would suggest, based on all the reasons that I've provided, we move away from a political, for the Supreme Court, we're talking now about the judicial branch of government, how to optimize it. I'd say we move away from a political, party-controlled nomination process for the next Supreme Court justice. And we move toward a more randomized, more unbiased, more objective process of deciding the next Supreme Court justice after one expires, of what I'll call automatic appellate promotion, of simply when one justice expires from the court, you simply promote the longest serving justice on one of the federal appeals courts, and that becomes the next Supreme Court justice. I think the element of randomization there ultimately ensures that the process is more objective, at least and that no one single judicial philosophy rules. Okay. And there may be some math behind that supports why, it's interesting. This video may be a bit longer, I mean, do we really want, I've talked about the intricacies of the differing philosophies in the judiciary. Why would we want this, why would we want, after, when we have this political nomination process, why would we want there to be, over the long term, one single ruling judicial philosophy? Is it not better that through a randomized, more objective, unbiased, politically unbiased, and party unbiased process, we simply ensure that there's some competition between these judicial philosophies that ultimately then kind of rebound off of each other over time and maybe produce results that are more objective in the long term. So I'm not sure, but Anyway, hopefully you enjoyed this video. Again, in my series on systematic government branch and government system optimization, I'd say that we move away from for the Supreme Court, we move away from the political nomination, party-controlled process for choosing the next Supreme Court justice, which only ensures that, we get a conservative or liberal justice, and move toward a more randomized process where of automatic appellate promotion, where when one Supreme Court justice expires, the longest serving member the longest serving justice on whichever one of the federal appeals courts it is, automatically is then promoted to the Supreme Court. I think this randomized process is better for reasons that I'll detail in the next video than the political process we currently have. Thank you for watching.